In this subunit, we'll discuss excuse of express conditions and conditions of satisfaction. All right, so as we already said, in this subunit, we're going to talk about excuse of conditions and conditions of satisfaction. First, let's talk about excuse of conditions. Let's refresh our memories. So remember, we said that express conditions must be strictly satisfied. So they're somewhat harsh, right? If you don't fulfill the express condition, if the express condition is not strictly satisfied, then it fails, which means the other party's obligation, whatever was the corresponding obligation to the express condition, that party will not have to perform that obligation. So we've seen situations where courts will avoid these harsh results if they can by interpreting an ambiguous clause as a promise rather than an express condition. So our previous example, we looked at XYZ brand nails to be used, and the contractor did not use XYZ brand nails. The contractor used a brand of nails that was just of slightly lower quality than XYZ brand nails. If this is an express condition, the condition fails and the homeowner does not have an obligation to buy the house. It's a very harsh result. XYZ brand nails seems to be ambiguous, so in those situations, a court would most likely interpret this phrase, this term in the contract, to be a promise rather than an express condition to avoid that harsh result. But what if the contract is not ambiguous? What if it is clearly an express condition? Can the court excuse that express condition to avoid the harsh result? Let's talk about that. All right, so there are three basic situations where a court might, not necessarily, where a court might excuse an express condition. Number one, relief from forfeiture. Number two, wrongful hindrance. And number three, non-cooperation. We'll talk about each of these in turn. All right, let's talk about a situation where a court might excuse an express condition because of forfeiture. Forfeiture is where one party would suffer a disproportionate loss, a disproportionate forfeiture, if we require strict satisfaction of the condition. Here's an example, and this is a common example. Lessee has an option to renew her lease, and the option must be exercised by a certain date. That is an express condition. If it's not exercised by that certain date, then she loses the option to renew the lease. Lessee is a day or two late on renewing her lease, and she has made significant improvements to the property in the expectation that she would be able to use it over the next several years. She's made a significant investment in the property. So if she can't renew her lease, then she loses that investment in the property. Okay? Will a court excuse the condition in this situation because of forfeiture? Well, the court will want to know several things. Number one, how late was the notice? Was it 1 day late? Was it a month late? Why was the notice late? Was the notice late because the lessee just overlooked it and was busy running her business? Or was it late because she wanted to speculate on the price of rentals in the market, right? Maybe she doesn't want to renew this lease because she thinks she can get a better rental someplace else. It turns out she can't, and she tries to renew the lease, but it's late. How much has lessee invested in the property? Remember, it has to involve forfeiture. And so if she's only invested a little bit in the property, maybe the court will not excuse the condition. And how much would the lessor suffer if we don't enforce this express condition strictly? Has the lessor in this time period from when the option expired until lessee gives notice that she wants to renew this lease, during this time period, did lessor find another tenant? If lessor found another tenant and is bound by that contract, then if we don't enforce the express condition and we give the lessee a right to renew the lease, then lessor is going to be in breach of this new lease. Remember, it's about disproportionate forfeiture. So we want to look at what the lessee in this case will suffer if we strictly enforce the express condition, and we want to look at what the lessor will suffer. What injury will the lessor suffer if we do not enforce the express condition strictly? All right, the next situation is hindrance, and this is where the party prevents the occurrence of the condition, or in a different type of condition, causes the condition to occur. Here is a typical example. So, contract for the sale of Blackacre is conditioned on a zoning change. We've seen this example before. Buyer later regrets the contract and hopes that the express condition fails, that there is no zoning change. So what buyer does is she bribes some of the members of the local zoning commission to not approve the zoning change, and therefore the condition fails. The court will excuse the condition. What does that mean, that the court will excuse the condition? The court will say, even though the condition has failed, buyer still has to go through with the purchase of this property. Why? Because she wrongfully hindered the occurrence of the condition. She wrongfully hindered the occurrence of the zoning change by bribing the local zoning officials. Finally, let's talk about a situation where a court might excuse an express condition because of non-cooperation of one of the parties. What does this mean? Well, it means a situation where an express condition has failed, but the court will say that the party who is seeking the protection of the express condition didn't do anything to help the occurrence, to aid in the occurrence of the express condition. In other words, the court is kind of saying that the express condition failed, but it failed because of you. And you might say, wait a minute, an express condition is an express condition. It's not a promise. We made a distinction between two of these. The party that is seeking protection of the express condition never promised that the express condition would occur. So, in these situations, the court is saying that the party who is seeking protection of the express condition had some sort of duty to help, to try and see that the express condition actually did occur and did not fail. It's usually in a situation where the party who is protected by the express condition really has some control over whether the express condition occurs or whether it fails. Here's a famous example. Imagine buyer and seller enter into a contract for the sale of Blackacre, and buyer's obligations to buy Blackacre are expressly conditioned on buyer getting financing. So what if buyer just never goes out and applies for a loan? Clearly, the express condition will fail. But a court in that situation will say that the buyer made an implicit promise to use good faith efforts to get the financing. Now, the buyer doesn't make an implicit promise to get the financing, to actually secure the financing, right? She might be rejected. But the court will say that because the financing condition, at least parts of it, are within your control, we will imply a promise on your part to make good faith efforts to get financing. Our final topic in this subunit involves conditions of satisfaction. And actually, it involves any time one party under a contract has the rights to decide something in her sole discretion. So let's look at this simple example. In the contract, it says, I will pay you if I am satisfied with your work. So imagine you are an artist and I hire you to create a work of art. And I say, I will pay you a certain dollar amount if I am satisfied with your work, right? That contract clause gives me a certain amount of discretion. Okay. What if you are a plumber and I hire you to fix my pipes and I say, I will pay you if I am satisfied with your work, right? It's the same situation. I have discretion under this contract to pay you or not, depending on whether I am satisfied with your work. So in these situations and in other situations where a party has discretion under the contract to decide a matter, the court will imply a promise of good faith. In other words, you have to exercise that discretion in good faith. Now, throughout this course, when we've talked about good faith, we've divided it into two different categories of good faith. There's subjective good faith and there's objective good faith. And for subjective good faith, the question that we ask is, was the promiser honestly not satisfied, right, for a matter of satisfaction? Objective good faith, the question we ask, would a reasonable person have been satisfied? So the question is, when we have a condition of satisfaction, do we apply the subjective standard or the objective standard? And the answer is, it depends on the situation. So if it's a situation that involves, if it's a contract, let's say, that involves taste, fancy, or likes, then we apply the subjective standard. If we have a contract that involves utility, fitness, and value, then we apply the objective standard. All right, so we had two basic fact patterns. One involved the hiring of an artist to do some sort of work, and I promised to pay for the work if I was satisfied. Now the question is, if I say I'm not satisfied and the artist sues me, what standard will the court use to look at my refusal to pay for the work? And the answer is, in this case, the subjective standard, right? Because art involves taste, fancy, or likes. And so when I refuse to pay for the work of art and the artist sues me, the question before the court will be, did I exercise my discretion in good faith? Was I honestly not satisfied with the work of art? Or was I just using my dissatisfaction? I really was satisfied, but I was just using that as a pretense for rejecting the work of art because I had some sort of regret about hiring someone to create a work of art, or maybe I ran out of money, or I wanted to use my money for something else. The situation involving the plumber involves utility, fitness, or value. So if I refuse to pay the plumber because I was not satisfied with his work, the court will ask, would a reasonable person have been satisfied with the work? So even if I was honestly not satisfied with the plumber's work, but a reasonable person would have been satisfied, then the court will say that I did not exercise my discretion in good faith and I still have to pay the plumber for his work.